All right, this session is going to be great. We are going to spend an hour or so with Joy Liddicoat. Joy joined the Office of the Privacy Commissioner about 3.5 years ago, I think, and she's a lawyer and she worked in her own private law practice offering legal services to the public and private sectors for more than 20 years. Her specialty is public law, including dispute resolution, privacy and human rights. Oh, come in. Is anybody sitting next to an empty chair? Throw a hand in the air if there is an empty chair near you, so that people can find their seats. Come on in. And there's a couple around the corner too that you can feel free to move, so it's cosy. And before the Office of the Privacy Commissioner, Joy was a commissioner with the Human Rights Commission, and she is also, you're currently Vice President of Internet NZ. Yes. Great. So we all settled in. Do you guys want chairs, or are you happy to float and do a standing desk kind of a situation? Excellent. All right, give a huge post-lunch, very woken up welcome to Joy Liddicoat.
Hi. Kia thanks, Michelle, and look, welcome everybody. Sorry to alarm you all by getting you to bring your chairs forward early, but thanks for being so attentive. I'm going to talk about access determinations. I'm just very mindful that you've had the whole half day with listening to people, so I'm going to do a little bit of checking in with all of you before I start. So the first thing is, has anybody here, just put your hand up, there's no shaming here, okay? So is everybody who knows what's in the new law about access determinations? Oh, thank goodness, nobody. That is great. Oh, sorry, you do. You've done your homework, go to the top of the class. So I can say anything and it won't matter, that's good. No, seriously, I do want to make that, because I know there's a variability of experience here. So can I just ask, who's a privacy officer in somewhere? A few more hands going up there. Come on, be proud. Good. Look, I mean, I think it's important to just acknowledge privacy officers. I think of them as human rights defenders. You know, you're the people who make sure that citizens who want to exercise their rights to privacy get their access to their information, have it corrected, deal with disclosures. So don't ever underestimate your role, and a shout out to all of those employers who aren't paying them enough, especially the women who we know only get 12%, less anyway. But seriously, this is going to be an important part of your role, is understanding how access determinations work and where they fit in the current processes. So I'll just walk you through it. I'm going to try and see if we can be a little bit interactive. And please feel free to ask questions and make things complicated and messy, because some areas are not really clear cut. We've got a couple of microphones. Sam's got one over there. There's also one here, so if anyone wants to just kind of come and stand up, and they can stand up there and ask their access question, or just put your hand up and we'll get a microphone to come to you. Okay? Anybody not supposed to be in the access determinations? You can just go. Just stay here anyway. All right, so I'm going to go through the why, the what and the when, and tell you what's up on these. Talk a little bit about enforcement. So these new directions, what are they, how are they going to work? And then also this thing called an appeal. So there'll be appeals from them as well. So just to sort of give you a heads up for the lawyers, the black letter lawyers, there'll be lots of clause references, things like that. And there'll also be some plain English explanations as well. So let's just start a little bit with the why. We've got this new provision. And it was interesting, I was talking with Rick Shearer this morning about this session, and he made a really insightful comment. Sorry to shout you out, Rick. But he said, look, in a way, the right of access to personal information is more important now than it's ever been. Because you can't know what's wrong about the information that's held about you unless you've got access to see it. You can't correct it if you don't know what's in there. You can't check its accuracy or have an agency on about its accuracy unless you know what they're seeing. And I think that very much resonates with our experience at the Office of the Privacy Commissioner. Still, well over half of the complaints that we get would be about access. I've asked an agency for my information, they haven't given it to me, or they haven't given me all of it, or they've withheld some of it and I don't know why. So it still is a very important right. And maybe another sort of element of the why is my experience as a disputes resolution professional is that generally in the background to an access request, there's something else going on. There's some other kind of dispute. I see people nodding. Would people agree? Yeah, in agencies, you know, someone's really upset about that service that they didn't get, or a benefit entitlement they felt that they should have got, which they didn't. Some decision's been made about them and they're upset about it. A business didn't give them some refund, or they're in debt collection. So it's really often used, I think, by complainants as a tool to equalise power, or what they perceive as a power imbalance. I mean, your experience in an agency might be that actually you're not feeling very empowered by the range or style or nature of access requests. But it's a really important thing to remember about our processes and the approach that we bring, which is to try and resolve disputes where we can, because we generally know that there's going to be often an ongoing relationship. You know, particularly if you're the Ministry of Social Development, or WINS, or Corrections, or Police, or a bank, or a finance company, chances are you're going to have this client for quite a long time. You want to get this right, and you want to repair the relationship and keep your client, keep your customer. So we do want to focus on resolution, which is very much what we do right now. So the why, it's important. Sometimes we don't manage to resolve disputes. At the moment, John, the Commissioner, is always laughing about how people think he's this, you know, got all these big teeth and he's a big privacy enforcer, and he says, no, I'm not. I don't have any power to make directions or order parties to do anything. Which is not to say that John is a gummy bear. I didn't say that. But it is true that we rely on powers of persuasion, on the constructive and responsive approach that government agencies and businesses take to our processes. And I would say for the most part, the agencies deal with it are good in that respect. They want to listen to what we've got to say, comply, with our recommendations, but not always. So this is a new power to issue an access direction to say, in those cases where we haven't been able to resolve it, or in a particular way, which I'll walk you through, the Commissioner's got power to issue an access direction. Anybody who is thinking we don't have that power right now, just pretend we do anyway, if you've been thinking we did, and complying with us accordingly. So what is it? What can the Commissioner direct an agency to do? All right. So the Commissioner can direct an agency to do any of these things by a specified date. So you're the lawyers, and you're already starting to picture that order, right, in your mind. You've got, thou shalt by this date. It's one of three things. One, confirm whether or not an agency holds personal information. Now that might seem a simple thing, well, do you hold it or not? Well, in actual fact, sometimes an agency might or might not know whether it has information, firstly, or secondly, it might be relying on a power to neither confirm nor deny it's got information. So that's what's currently in Section 32 of the Privacy Act. And there are certain circumstances in which an agency can say, look, I'm not going to confirm or deny I've got this because it might prejudice a particular interest, national security, or it might give rise to other issues. And for those of you who haven't read the bill, there's quite a new important distinction that's being brought in Principle 6 of the Privacy Act. So Principle 6 says a person's got a right to request access to their personal information from an agency. The bill provides that a person can request two things. Firstly, confirmation that an agency holds the information, and secondly, access to the information. Now, we've got some questions about that, and I'd encourage those agencies who are looking at this part of the bill to think about it quite carefully, because at the moment you don't have to generally confirm and then give access, you just basically give access. So, there is a question of whether this might create sort of a two-tier process, whereas at the moment it's pretty straightforward. I'd be interested in your thoughts on that. But this is essentially, we think, why there's this confirmation. So the first thing, we can order an agency to confirm that it has it. Note that it's to hold any specified information. So many of the agencies that work with us, what we end up creating for a complainant when they request information, we request that agencies show us everything that's in question, and we create tables. We say, like, this document dated this date from that person to that person. So it's pretty specific. It's not just an empty your pockets kind of request, show us everything. It has to be for something specific. And that's going to have implications for you and agencies, right? So that if you're wanting to withhold stuff, you need to be really clear what it is that you're withholding. The second kind of direction is to permit a complainant access to information. So we might direct that. So look, you're trying to withhold this information on the grounds that it's that disclosure would involve the unwarranted disclosure of the affairs of another person. Is that right? Yeah, would involve an unwarranted disclosure of the affairs of another person. And we're saying, well, actually, we don't think that's the case. We can order that you give the complainant access to it. And then thirdly is to make information available to a complainant in a particular way. So currently there's quite a lot of flexibility about how you can do this. So it might be, here's a USB stick, go away, download it. It might be, come to our office and pick up these paper folders and take them away. It might be, look, we're not going to give you all the information, but sit with me and I'll just tell you what's in it. So you can do that orally. Or it might be, some kind of written summary, or increasingly in these technological days, some kind of sort of overview as well. So it's quite interesting, isn't it? So those are the three things that the Commissioner can direct an agency to do. That's in Clause 96 of the bill. Can I just stop there and ask, has anyone got any questions just about this so far? I can see a few furrowed brows. I'm thinking, what are you thinking? Yes, I've got one here and then one back. Yep.
I'm just sort of curious how this applies to information held overseas. So, for example, any marketing or advertising agencies over here where they collect personally identifiable information, but that's sort of stored in Ireland or Netherlands, and the contract is executed online. Does the Commission still have power? Because I'm guessing this is going to be enforced to the New Zealand subsidiary or the company, so they could just refuse and say, well, we actually don't hold it here, or?
Great question. Well, under the Privacy Act as it's currently framed and as it will be in the bill, it doesn't really matter if the information is held here in New Zealand. So Section 10 of the current Privacy Act says if it's personal information about a New Zealand, about someone in New Zealand, then a person's entitled to request access. So, for example, the Commission did recently name Facebook in relation to an access request where Facebook declined to provide us with information that the Commissioner requested. The fact that it was held overseas was irrelevant to that determination.
Hi, Joy. Currently, the Commissioner, as you know, has got powers to summons people, which are used fairly sparingly. Is it envisaged that this would be a last resort sort of scenario, or would it be just something that went along with a finding in relation to an access request?
Yeah, that's
a matter of course.
It's a really great question. So it segues perfectly to my next slide. Thank you, Seb. So when can a direction be made? And I think this is important because this is actually quite a separate power from any power to require an agency to give us information, all right? So the direction can only be made after an investigation has been completed. So any ordinary common sense person would think, oh, that's easy to understand. It's just after an investigation's been completed. But what does that actually mean? I see the lawyers shaking their heads. And when is an investigation completed? So at the moment, and it's, again, I would encourage agencies to have a look at this because we see a couple of issues. One is that at the moment, we can turn our minds to these things after making any investigation. So that might mean starting one, getting halfway through, doing some preliminary inquiry sort of thing. After an investigation suggests in the construct of the bill that we've actually come right to the end of our process and made certain findings of fact. Now, part of our responsibility is to use our best endeavours to resolve a complaint. Now, it might be that we've got a complaint that involves, look, I requested access to my information, they haven't given it. What's more, I've got a request that they correct it, which they haven't done. And by the way, they gave it to someone else without checking it. So those relate to Principles 7 and Principles 8. So this section will only apply after we've completed an investigation into the Principle 6 issue. So we're really not sure how this is going to fit with multiple principles, and also it might be, for example, helpful to an investigation in that kind of scenario. We say, look, we're going to make an access direction. You're going to make the information available, and then we can deal with the disclosure, or then we can deal with correction, then we can deal with the Principle 8 issue. So we do see, I think, some issues about when the direction can be made, but at this point, it's not intended as a search and seizure type provision. It's not intended as a tool to require an agency to give us information. It's not. This is about giving access to the complainant. It's not about giving access to the commissioner.
Hi, Joy.
Hi.
Just thinking about the conversations we've had this morning about algorithms and data being put in to do predictive risk modellings that we had this morning around the definition of, and then you're talking about organisations saying we'll give you this but we're going to withhold that, around the definition of the personal information, what's classified, because with the algorithm and predictive risk modelling in particular, they're taking factors that they've worked out, if you have this situation and that, you're more likely to, and then applying that. So agencies themselves are adding data to the personal, the child and the family's file about, and that becomes about them. So how does that fit with, you were talking about a person might not know they've got that, they do that and put that data and that becomes data about them. How do you see that fitting for requests?
Well, helpfully, the definition of personal information in the bill is as wide as the current definition. So this issue has already come up to some extent, particularly around data portability. So that, for those who don't know, data portability is the right to say, hey, social media platform A, I want to take all of my data from you, and I want to be able to take it and give it to this other data. So I want to be able to, I want that data to be portable. And the social media platforms are going, well, how far does that go into the information? What about our intellectual property and how we curate the data? Do we have to make it available in a particular way? Or, well, we'll make it available, but it's completely unusable for you because you don't have the intellectual property to unpick it. What does that mean then in terms of meaningful access? So, which is to say, it's a real issue. It's an issue now, regardless of the bill. I don't know that the answers are clear in all cases, and I do think it's going to be useful to be able to have a power to specify the way in which information can be made available. So if it is unintelligible in some form, but the parties can agree, or the Commissioner determines, look, we think in this particular instance there's a way you could make that information available or provide it to them, then that may be an area for a determination.
Just picking up on that point and going back to there, that very much deals with specific information. So where do we go when we have a client that believes an organisation has information on them, but they have no idea what information they have? So in effect, they are wanting to go on and do a search and seize because they can't specify because they don't know.
Well, the way that we would generally, and actually I see this every day with agencies who I do think make a pretty good fist of trying to discern what access requests are being made to them. We do have, often members of the public aren't able to frame their access requests clearly, or they might just say, give me everything between the 1st of July 2014 and the 19th of November 2018. And then an agency's going, do you really want everything? Or is it a particular thing? So part of our role, and I think it's one that we try to work with agencies and complainants actually to the spirit of the request as well as to the letter of the request. So it might be that we're helping a complainant shape their request down and say, look, I know you've asked for 4 years worth, but what's that background issue that's going on there? What's the real thing that you need or that you're worried about? So that's one thing. The second thing is that we ask all the agencies to give us all the information they think falls within that request. So we can have a look at it. And so sometimes we'll say to a complainant, look, I know you think that they've got a whole lot of information about you. We think that the agency's got reasonable grounds to withhold it for a variety of reasons. We've seen the information and we're satisfied that they do have grounds to withhold it. Or we've seen the information, we're satisfied actually, we can't make a finding that they are withholding anything from you. So and we do get good cooperation. I mean, some agencies will let us come and go through their, computer files and systems like that. We don't need to often. So that's one way in which we do that now without any powers of audit, and we're not seeking those kind of things for the purposes of this kind of access direction. This we envisage would be more at the end of an investigation where, for whatever reason, you haven't been able to resolve the request. Okay, it's time for an access direction, and that would be something we would discuss with the parties beforehand. We wouldn't. As part of our dispute resolution and investigation process, we'd be saying, look, this looks like one where if you aren't going to provide it, we might have to issue an access direction, at which point an agency might say, okay, I'm fine, or no, I feel very strongly on this, we won't.
Because it also comes into the correction for people, because where I run into it is people don't know what information is held, but they believe that there may be some misinformation.
Yes.
But they can't specify.
Yep.
So it makes it very difficult to frame a request at the moment.
Yeah, and as I say, there are obligations on agencies to help requesters with their request, and I do see agencies doing a pretty good job of trying to do that. I mean, sometimes it depends. I've got one I'm investigating at the moment. It relates to an IRD matter, and the particular complainant is convinced that this agency has got something about her that is the reason why their student loan, was they had to pay it back early, and there isn't anything necessarily there. It's just actually that they're concerned about this dispute and they've got into their head this thing, and so part of our process is to try and reassure about that and to try and get the agency to give reasons for decisions which help reassure the complainant.
Just to add slightly to this, how does this impact on the cross-government agency sharing of information, where that specified information might be across multiple agencies?
So in terms of information sharing agreements, they're sort of generally outside the scope of an access determination because they're set up under a different part of the Act. But your question's a good one. So what happens if the request has been made to MSD and it's not only information they've got, but say corrections and police and 3 or 4 other agencies have got it? Generally, we'd only require the agency to whom the request has been made to comply with the access direction. But it would be a good question, I suppose, for an agency that might be subject to this to ask. And one thing that we think is a bit of a gap, actually, in the bill, and I'd be interested in your thoughts on it, is at the moment there's no power to vary or cancel the determination. So we can envisage circumstances where an order is made and it needs to be changed for some reason, or it turns out it was, with having a direction, somebody's gone and had another look and it's already been given, or the complainant withdraws, or for some other reason in the vicissitudes of life, there might be a valid reason why an order needs to be varied or cancelled. And that could be one, particularly for government agencies, to have a bit of a think about whether that kind of power might be useful.
So just a quick question about, in terms of an agency, if you get an access determination, is the Commissioner going to, what's he going to do with that information?
Right.
So if you're an agency that finds itself on the scoreboard for a dozen of these determinations, is there any onus on the Commissioner to come in and talk about patterns of behaviour that they're seeing around agencies? What's going to happen in that respect?
Yeah, that's a good question. So this sort of power is quite different or separate from the compliance power, which I think the other session that's on at the moment is about, which is looking really more at the systemic issue of demonstrate agency that you are going to show compliance. Now, I think in practice, actually a lot of agencies are showing us that already as part of our investigations processes. I see lots of agencies, because our primary duty is to use our best endeavours to get an apology if there has been an interference with privacy and a reassurance that this won't happen again. And that reassurance part is generally where agencies will say, hey, look, this was a really terrible case. We've updated our privacy policy, or look, that was a heads up. That was pretty awful. Here's how we're going to make sure that won't happen again. So you are, in a sense, the agencies are, in a sense, demonstrating their compliance. And I think the compliance, where we see systemic, I think that's where that compliance side will go rather than access directions. Although, if there were 12, I'd like to be thinking that the office would be thinking about that probably at about number 5 or 6, and trying to help agencies with compliance too. Interestingly, also, look, there might be situations where an agency says, look, can you please give us an access direction? Because actually it would help us a lot if you could just get this complainant to see that this is okay to make it available to them in this way. And we do see that occasionally where an agency feels a bit frustrated with how either the volume of complaints or access requests or the way in which they've been framed. But I imagine that being unusual. In most cases, this power is really designed to be another sort of tool for us to use in situations where a complainant's not getting access to information that we're saying they have a lawful basis for. Yes?
Yeah, Joy. There was a comment over here that sort of suggested that people need to be able to specify exactly what information they're looking for. I think of it as legitimate for people to say to an agency, give me everything you hold about me, and for that to be kind of the extent of the request. Could you comment on if there is any distinction?
Oh, you're absolutely entitled to request all the information that an agency holds about you, absolutely. You don't have to know what it is, because that's why you might be requesting. I suppose my point was also to say, that we also work to help agencies and requesters sometimes, if they can be more specific, so that the administrative burden on an agency isn't as much, or look, they're requesting 10 years worth of information, they're probably not going to get it within 20 working days. So if it's really important that they need a particular piece of information sooner than that, we're trying to sort of help problem solve. But you are, anyone is perfectly entitled to go to an agency and simply say, tell me all the personal information you've got about me. Yep. Cool. Shall we just keep tripping through? So when can it be made? I said at an end. Question mark there about, will that always be the best place to use an access direction? Might it be helpful to use it earlier, particularly where you've got more than one issue, a principle involved? So how's it going to be enforced? Well, failure to comply with the determination will be a criminal offence, punishable by a fine of up to $10,000. And remembering that the access direction will specify the date by which information has to be made available. So I suppose a question that we have in there is, should there be a time period within which you have to enforce the access direction? Or can it just sit there for a year or 2 years or however long? Can't imagine that situation coming up very often, but again, just something to think about. I've mentioned, should there be a power to vary or cancel an order? Interestingly enough, the tribunal can, and I'll talk a little bit about this in a minute, sort of appeals that can go through to the tribunal. But the way in which an order is enforced is that the complainant can, if they're unhappy with our access determination, they can go to the tribunal in the normal way. If a respondent agency is unhappy with the direction, they can appeal the direction. Just move on to there. So, where am I going? Appeals there. So the office makes an access determination. Appeal period is 20 days, 20 working days. Now, the idea of that is so that it's quick, so that this is supposed to be, after an investigation, when the issues are clear, when the information in question is clear, an access direction is made. Okay, respondent agency, you've got 20 working days to appeal. But it can be up to 3 months in exceptional circumstances. And I'm really interested in what large agencies have got to say about this, because, an appeal procedure, it can be quite onerous in terms of making sure that your organisation knows that you've got this access determination when the clock starts ticking on the appeal period, and what might be exceptional circumstances in which you might want to apply or appeal up to 3 months after it's been made. So that's just something to think about there. In terms of appeals, the Commissioner can only be heard if the appeal is a hearing, in other words, if it's actually in person. So the Commissioner is not entitled to be heard on the papers. So really it's just the idea is that the respondent agency and the complainant are hopefully quickly working out whether the appeal upholds the direction or not. And if the tribunal can either confirm it, modify it, or reverse it. So that's the intermediate step there.
That seems a little odd to me. If I look at other regulators who have this sort of power,
Yep.
Normally it's an appeal against the regulator, and so it's the regulator who's the party on the appeal, and you would expect that because the regulator is often going to be better resourced than an individual complainant, will have gone through all of the detailed exercises as to whether the withholding of the access was legitimate or not. So it's almost like the poor old complainant is back at square one, having to launch a fully blown appeal against an agency who will undoubtedly will often be better resourced and who's already gone through the argument with the Commission about whether the access is to be given or not. That seems very unweighted, if that's the right word for it.
Yeah, well, I think the model is really designed that it's more by way of supposed to be a fast administrative style review by the tribunal at the request of the respondent agency. So if the complainant's not happy with the access direction, they actually have to take the normal route to the tribunal, which is to complain essentially about the Commissioner's findings. So the provisions here, I think this is why the Commissioner's got power to appear in proceedings where they're heard in person. But we did find it a little bit unusual, perhaps, that the Commissioner couldn't necessarily be there if it's required on the papers. There's also a sort of a slightly odd provision in the bill which says that the tribunal can stay the access determination pending an appeal. Now, that seems a bit odd because in the general course of procedure, if you appeal, it generally operates as a stay. So I don't know if that's for the avoidance of doubt, but I think this one might actually be worth a workshop sort of among some of the agencies themselves to figure out, how might this work. Yeah, so I think there are still some little aspects of that need to be worked through. So one issue that might come up is just how you verify that you've complied with an access direction. So you get the access direction and say, okay, right, I'm going to give the information to the complainant in this particular way. And then the complainant says, the requester says, oh, you didn't do it. And you're like, yeah, I did. No, you didn't. And so, what might be some steps that you might want to take to verify to the Commissioner that the information has been made available. I mean, we deal with this quite a lot at the moment where agencies will write to us and tell us, but I would just be encouraging you to be thinking about that, making sure that your processes include just letting us know. It's all sorted, it's done. Okay. So I just want to come back to this bit here on what direction can be made, just so you get a bit more of a feel for the kind of things that might happen. So, and this is where it does get a bit tricky, and you need to do a lot of flipping to the end of the bill and coming back to the beginning and going back and forth. So this question about whether or not the agency is required to confirm that it holds any information. There are some new provisions about confirmation that information exists in the clauses that are up there for the black letter lawyers. So it is going to pay to check if you are giving reasons why you won't confirm that information exists or not, that you're actually really clearly documenting those. A good example is the intelligence agencies, actually. They are on public record as saying this because we do get complaints about them. And one of the things they'll say is, look, you know, we will sometimes decline to tell anybody whether or not information exists about them, whether or not we have any, because there are unknown third parties that look for patterns in our release of information, in our decisions. And if they can determine who from this patchwork quilt are the sorts of people we don't hold information about, they might use that to target certain people for their nefarious purposes. So we will not have clear patterns to when we confirm or deny. So you can imagine that, you know, and that can be a legitimate security reason for neither confirming nor denying in a particular case. So we'd always want an agency to be saying in a particular case and not have a blanket rule. So sometimes, for example, the intelligence agencies will say, look, this person seems to be unusual perception, they seem to think that there are helicopters chasing them, we actually want to put their mind at rest, and we will confirm that we don't hold any information about them because we don't want them worrying. So in terms of thinking about whether or not there are reasons to withhold neither confirm nor deny information, and there might be times when your information falls in that category, it will be important for you to be documenting those reasons and having a good look at those new provisions in the bill. And we'll be having to think about, well, what factors do we want to take into account in determining whether or not you should be required to confirm that you have information. Sometimes it's a compassionate thing, for like the example I just used, where somebody's clearly unwell, or has a distorted sense of the attention that they might be receiving from, you know, a particular agency, and you know, it's about saying, look, you know, we think in this particular case this confirmation is warranted. The other thing is just in terms of permitting access to information. I've talked a little bit about the ways to make information available. I do think agencies have got some room for innovation here. So if you do want to think about some new ways of making information available that don't involve press print, give somebody a whole lot of documents, then I think there's scope for that. And I think as we see new forms of technology, we'll see more of that. For example, we had, when the corrections GPS ankle bracelets came out, you know, the ones that track where someone's going. We had an inmate who requested all of the GPS coordinates that the Department of Corrections held about them because they wanted to be able to show that they weren't in a particular place at a particular time, which they were currently on trial for. You know, is that a reason? You know, is that readily retrievable? It wasn't readily retrievable. No. Might there be another way to make that information available? Yes, there was. That, you know, so that was permissible. We probably can't foresee sort of other kinds of types of information that might be gathered or innovative ways to make it available. But it's something to be thinking about when you're getting these access requests, and also when you're working with the teams that are designing some of these new processes. And then, yeah, by a specific date. So, you know, this I think will very much depend on the circumstances. So probably in the first instance, we'll be looking at, you know, the 20 working days that are already in the bill and in the current act for making information available. But there might be circumstances where that's not appropriate. If the information is a large amount of information, if it's sourced over a whole range of different forms, paper, computer, intelligence or otherwise. So the main thing is just having a specific date. And I would imagine that would be a point for discussion with agencies, is what's reasonable in your context. And then taking that into account in terms of specifying a particular date. All right, questions? Yes, I think we need to get you a microphone. Oh, well then, off you go.
Joy, there was a mention before about agencies potentially requesting orders to be made. I was wondering whether it was a possibility to actually have that almost as a way of communicating publicly, like this is what we think, like in areas like, I'm thinking of algorithms, in a very formal kind of inarguable way, this is what we'd expect to be released.
Yeah, I think as I say, I think there's a chance for some innovation there, and there could even be some guidance as a result of that what is best practice in terms of specifying the manner of information and what information, particularly where it's highly technical. It's kind of interesting, isn't it, listening to that discussion, that panel this morning about whether it's possible to make information available in a way that's comprehensible. And I know in the consumer context in the US and in the European Union, there's been some discussion about, well, what's the obligation to explain the incomprehensible data? You know, you can't just give, 50 pages of a printed out encryption key. So it could well be that is a helpful point around issuing guidance for manner of information made available.
So the date thing was sounding like it was mostly about the administrative task of getting the data. What considerations will be made where the timeframes are about a decision that could be made by somebody incorrectly if that data, if that information is wrong and somebody's seeking to get it, find out what that information is that they have? So is that taken into consideration in setting and thinking about the timeframe? So a decision is going to be made about the person, but they believe there's wrong information. It's a bit like your student loan that was after the fact, but they could be trying to get information before a certain decision's made. How will that fit within determining the timeframes?
It's a really good question. This often comes up where in employment disputes. So you used to see it a lot more when I started at the office, but we see it less now. But occasionally, there's some working relationship breaks down, there's a personal grievance, or there's some allegation of constructive dismissal. They're off on the track of the MB mediation service and through to the Employment Relations Authority, and somewhere in that track they make an access request for all of their personal information. The 20 working days starts, and it's not complied with, or only in part, and then it comes to us for review. And we are, in that kind of case, very, very mindful of getting the parties together to say we don't want competing jurisdictions happening at the same time. Tell us if you've got a date for your personal grievance areas, tell us what it is. By the way, mediation services, they don't need full disclosure for mediations, and the authority can make orders that you disclose to each other relevant documents. So are you sure you need our process? So I suppose in a practical way, or if there's other kind of court hearing coming up, a district court hearing, we would try and get the parties to work together to meet that. I think the tricky part of your question, which is why it's a good one, is where it's more than one principle, because Clause 99 in the bill, and I really would encourage people to look at this, is that it says that it deals with procedures after investigations of principles other than Principle 6. So it says, okay, when Principle 6, after that investigation is completed, you can make an access direction. In all the other cases, here's what you can do. Now, I just wonder about the practicality of that in cases where, and the fairness in a way, both on respondents and also on complainants, of then possibly having two parts to a sort of an issue arising out of a single set of circumstances, and not dealing with something holistically. We do wonder whether that might cause some practical difficulties if you've got to wait till the access one's finished before you, and then make a direction. Yeah. So look, I think we've got some thinking through to do about it. We're very interested in what people have to say. Maybe we don't need to worry. It'll be fine. But at the moment, it's kind of calibrated in a particular way. I would say also, look, we would be wanting to talk really closely with the respondent agency about access and determination before we issued it. So you would be through the process of us attempting to resolve it, know what the information and issue is, know the reasons why they're not giving it, that kind of thing. So it shouldn't be a surprise that then suddenly there's you would be signalling it kind of early, that kind of thing.
So as more and more data gets linked together, so personal data about me is also personal data about someone else, because they're my friend on Facebook or whatever else it might be. I think we're going to get more and more situations where agencies are struck with the terrible decision as to whether they give access because a complainant has requested it, or withhold access on the basis that
that it's an unwarranted interference with the privacy of someone else.
Someone else, yeah.
So to Seb's point, I wonder whether access directions could be quite helpful to the agency in that circumstance, because they can say, hey, look, we don't know, go and get an access direction from the Privacy Commissioner, and then our hands are clean, they don't have to make that decision. But my question is whether in that circumstance on appeal, or so the agency has had the access request made but disagrees with it, and so wants to appeal, whether the other person, the person that the agency says unwarrantedly has had their privacy interfered with,
the third party,
should also be able to appear on that appeal.
That's a really good point.
Because it's really it's not the agency against the complainant, it's effectively two parties who they're trying to mediate between.
Yes, I think at the moment that would be dealt with by way of affidavit evidence from the respondent agency, basically referring to why it was an unwarranted disclosure of the affairs of that person, and possibly even if affidavit evidence from that third party. It's quite common where you've got family members who don't want information disclosed to each other, or relationships that have broken down where people are saying, I've got a protection order, I don't want them to know where I am. That kind of thing. Again, I would have thought that we'd also be looking at that during an investigation, as saying, look, those appear to be good reasons for non-disclosure. It comes up quite a bit already in some of the social media platforms that we deal with, where it's kind of interesting because, I don't know, it's a bit like positive feedback about sessions that you facilitate. You see all the positive feedback, oh, that's awesome, and then you see that one bad comment, like, oh no, I can't believe I did that, and you look at the thing that is negative. And I see this a lot with people who get redacted information from an agency. Their eyes are drawn to the blank part that they're not allowed to see. Even where it's, particularly where it's perfectly lawful that they're not seeing it. So I think in that kind of scenario, our role is to make sure that we can say to the agency, look, we're satisfied you've got reasons, and to the complainant, look, we're satisfied there's good grounds to withhold this from you, and look at all this other lovely stuff that you can see.
Yeah, I'd just like to revisit the question I asked around the cross-government agency sharing of information. This release of information, if somebody makes a request for that information, are we required to disclose that we've actually shared it with another agency?
Well, that may be part of, that might be part of an access request. So, I mean, it happens quite a lot already. So, in the health information area, for example, someone might say, I want a copy of the audit trail of who's accessed my health information. And the health agency will give them an audit saying, or people who've accessed it, and generally, the reason for it. I mean, this came up in one case I dealt with a couple of years ago, where it was an employee browsing case. We've done a case note on it where an employee was just kind of browsing a couple of files a day that they, a bit bored, scrolling around, VIPs, staff members. Oh God, people are laughing. I hope that's not in a knowing way. And VIPs who are coming into the health practice, family members, staff members, family, just kind of, and over the course of 3.5 years, had looked at 1,300 people's health information. And it so happened that in this particular complaint that it came to us, it involved a particular person who, they'd found out about this because one of the people in the practice was listening to this person talk over morning tea, and thought, oh, I wonder how she knows that. It's a bit odd. So they went and had a bit of a look, and turned out that there'd been this disclosure. And then we got a complaint from one of the persons who'd been browsed. And then she said, okay, I want an audit. I want an audit of everybody who's looked at my file. I want to see for whatever reason. And actually, there were dozens of people who'd looked at the file, many of them for perfectly valid reasons, but which can be quite intimidating and frightening when you first look at it and think, oh my God, there's 50 people. They're all interested in my polyps. And no, they're not. They're just the receptionist and the admin person and the billing person and the, So, yes, as part of that might come up also, who it's been shared with, and that would be different from an information sharing agreement, arrangement where there's different processes in place. But again, if you're dealing with people who are worried about where their information is going, getting some of that up front with the purpose when you collect it, keeping people up to date with, hey, this is how your information's being used, so there are no surprises there. Once we had a complaint from someone who said, it's a breach of my privacy because the admin officer has opened the envelope that was addressed to, say, Joy, and then passed it to someone else who's date stamped and entered it into the machine, and then passed it to the person I addressed it to. It's a breach of my privacy. I said, no, that's not a breach of your privacy. An agency is entitled to have more than one person handle the information so that it gets to where it's going. It's covered already under Section 3. So I suppose that's to say part of our role also is to reassure complainants. There may be, and to help agencies themselves reassure complainants, look, there are perfectly legitimate reasons why others might have your information, but hey, that wasn't.
We'll often have requests made where it's dispute or grievance related and they're looking for some kind of smoking gun. And of course we won't find anything, but because we're part of the agency they've got a dispute with, they're not necessarily inclined to believe that we haven't found anything, and it kind of feeds into the issue. Would this service be possible for the agency to say, look, these are the steps we've taken, we've got the Privacy Commissioner to independently verify that these are appropriate steps, in the hope of resolving the dispute a bit quicker?
Yeah, I think in that kind of scenario, generally what I'd hope is that we would just find there was no interference. So we'd just be saying to the complainant, the way I try to frame it to complainants is to say, thanks for your complaint. We've worked with the respondent agency. We've seen the information in question. We're satisfied they fulfilled their obligations to you and that there's nothing that they're withholding from you or something like that. So that they can say, and say, look, I hope you feel at least satisfied, even if that wasn't the answer that you were seeking, that you feel satisfied that bringing your complaint has allowed us to be able to assure you of this thing. Sometimes that works for people, sometimes it doesn't. But the other thing that I would say to that is that if you deal with that background complaint, that background reason why they've made the access request, that will also help. The fact that they got really bad service from that manager who intimated they knew something when actually the manager was just having a bad day, then that might help in those kinds of situations.
I just want to pick up on the cross-agency stuff of sharing of information. If an access direction did mean that information was made available and there was incorrect information that needed to be corrected, where's the onus, and that incorrect information was shared by that agency with others, where does the responsibility lie to clean that trail up?
Yeah, well, I think this question goes back to the point I was making earlier about the fact that this power to make access directions is decoupled from the power, the procedures after investigations into other principles. Because of course, it might be that in getting access to the information, not only the complainant but also the respondent realises that it's wrong. So there are some new powers in the bill to disclose information and in relation to correction. And I'd encourage you to have a look at those. Generally, it might be that as part of a settlement, an agency agrees to do that, to advise another agency that has the information. You might have it wrong, but remember that any agency's still got their obligations under Principle 8, so they still have to check that it's accurate and not misleading and up to date before they use it anyway. So, yeah, that would be my answer there. Yes. More questions?
Just one last question. I wanted to know if, say, for example, my data is collected, say, from birth, for that particular reason.
For what reason, sorry?
It's my birth data.
Oh, your birth date. Oh, sorry, yeah, okay. I didn't quite hear the question.
And it's collected for government records, but then, no, down the track, somebody discovers that it's really useful to have people's birth dates to do research. Have I agreed to that? Or, how does it work?
Well, Principle 10 basically covers use of information for research purposes. So there are circumstances in which an agency can use information for research purposes. So the answer to your question is that it might be possible. Depends if they fit within the frame of Principle 10. One of the questions that I know that the Commissioner is putting out and encouraging people to respond to is whether or not there should be a specific principle to prevent re-identification of information. So this is around making sure that data that is passed on for research purposes and which is anonymised or certain data components are taken out so that the original source information can't be linked to a particular individual. Some kind of principle which strengthens and supports that and prohibits re-identification or places obligations on agencies where re-identification occurs. So that's not included in the bill. I think it is one that they'll be looking at submissions on, and there's some information about that on our website if you want to have a look.
Thank you.
Yeah. How are we going for time? 4 minutes? Okay. What have we got? Anybody's brain exploding with all that information? Yes, I've got one at the back here. Can I just take this one at the back here, Seb? Sorry. You've asked 3 questions already. Savannah? Yeah. Whether they will be publicly available. Yeah, it's a good question. I mean, at the moment we don't, the secrecy provisions of the Act mean that we don't publicise individual settlements. I mean, and generally parties sign settlements that are, confidential. We might, by agreement, publish an access direction. So if both parties, like I think who was saying, hey, look, it might be helpful if there was some clarity on the manner in which it's okay to make information available in a particular case. Might be we just did that by a case note rather than publishing the actual access direction. But I think it's a good question because it might be, I can see good reasons why it would be helpful to publish information about the early ones so that people get a feel for, what kinds of cases and guidance and things like that. So, thanks, Ed. Yes.
Hi, Joy.
Hi.
I was wondering if you would be prepared to comment on the likely impact, if the bill passes, on the time frame of investigations. As you know, it can be a somewhat laborious process with the to and fro from the complainant to the respondent, and can take a number of months. With the new powers, do you see that process as likely to be quicker or slower?
Right. I'm trying not to be defensive about the speed of our investigation.
And
but anyway,
it's
I just want to point out that,
resources.
they have dropped from over 2 years to under 6 months in 90% of cases. But anyway, I think it's a really good point because sometimes it's really clear, really early, that actually access should be made available, and an agency is struggling with that. So it might be that in some cases it gives a tool to move really quickly a lot earlier, and I would hope that even being able to signal that to an agency and say, look, don't muck around here because we're going to make an access to, we have this power, and that might help. So, yeah, I mean, I suppose the other sort of side of it is you also want to make sure, particularly, I feel for small businesses, to be honest, a lot, because, I've had any number of mechanics and printer operators, shop operators and heat pump installers, who've got some sort of dispute with their customer who's making access requests about and they're just going, privacy. What is the Privacy Act? I don't know. And they genuinely want to put things right, but get a bit overwhelmed by things. So I wouldn't like to think that we'd be doing that in cases where that's burdensome, particularly in a sort of regulatory context on small businesses. But again, it might be interesting to think about, when the sorts of cases showing early on where we're issuing them. But yeah, the faster you can get disputes resolved, honestly, the better. Yeah. Thank you. Catherine.
Can I say raise one thing? I think it was raised along here, and I'm not sure whether I didn't quite get your response. But I thought the implication was, is there an opportunity for agencies before they decide on responding to a request to come to your office to say, this is what the person wants, this is what our response is, would you give an access direction to the agency rather than waiting for a complaint? Is that sort of the gist of what was being asked here by you?
I think we'd probably put that more by way of an advisory opinion, because because I think it's problematic because we can't actually issue an access direction until after an investigation under the bill. So
I guess that what I'm getting at too is, as you know, we're with police, and a lot of our information is in the nature of mixed information about and highly sensitive. And so making the call on whether to disclose or whether not to disclose what they know already and what they don't is often very difficult.
Yes.
And while we have good faith protection under the Act, nevertheless, we don't want to make mistakes. And it would be helpful, I guess, to have some help there. And also, the other thing we have lots of, perhaps more than a lot of other small agencies, are requesters whose bona fides aren't particularly good. They are actually just trying to make life difficult, I think, for the people that they thought made life difficult for them, I guess. And so their requests are often unreasonable in the sense that, for example, they've already had almost everything we have in criminal disclosure, but they want it again, and they want every other bit, so on. So again, the intervention of the office to look at whether such a request would be reasonable. We're sort of looking at ways to overcome that particular problem for ourselves, which costs the taxpayer a lot of money in time.
Yes. You always ask great questions, Catherine. I love you. I do. And also, just acknowledge, police do get a lot of quite complex and quite fraught requests, and generally, do a really great job of responding to them in a timely way. A thing I think to note is that there are some new grounds for refusing requests, particularly around harassment and harassing type nature, so I'd really encourage you to have a good look at that. I remember a complaint about a request to an agency that was for all the information you're going to create about me in the future. So anything that you might do, and every 6 months, I just want to. And we said, no, you're not obliged to give information that you don't hold. So look, which is it's just to acknowledge that reality that you're saying, Catherine, is that you can get requests of a particular kind. I don't think there's any new thing needed for that. I mean, I think agencies do a pretty good job with that already. But if there was, an idea of some guidance, particularly around, you deciding, say, early, that a complaint's of a particular nature, doing that quickly, and then getting it, telling the complainant to come to our office. So yeah, I don't know, because of the way the bill's framed, we can't really deal with those until the end of an investigation. And if you think that's an issue for you, or you'd like more flexibility, then I'd encourage you to be talking about that with other agencies. I know it's a bit problematic for police to make submissions on the bill, but even with justice and so on. Yeah.
We're going to have to leave it there, Joy.
Are we?
Yes, we are, okay. Because I know you're starving. It's afternoon tea time. Thank God.
I need a cuppa.
I haven't eaten for nearly an hour. So, huge round of applause for Joy. What a great interaction.
Thank you.